Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this set of videos, we are talking about the CSPA, or Child Status Protection Act. And in the prior videos, we discussed what would happen if, for example, a petition was filed by a lawful permanent resident parent, and that lawful permanent resident parent becomes a citizen prior to when the child turns 21, and how that locks the child's age in under the CSPA for all time, and that child is able, no matter how old, in reality, able to be a child for immigration purposes under the CSPA. But what happens when the petitioner parent becomes a citizen and the child is over 21 at the time the child becomes the petitioner becomes a citizen? Well, in most cases, when a parent becomes a U.S. citizen rather than a resident, it moves the priority date years closer, and therefore decreases the amount of waiting time that has to occur by years. Well, under the CSPA, is a provision where this automatic conversion, and by automatic conversion I mean initially the preference would be F2B, a child under 21 of a lawful permanent resident, and then of course when the parent becomes a U.S. citizen and the child's over 21, it then moves to the first preference family-based petition, in which case there are many more years that the person does not have to wait. However, there is an exception, and that's from the Philippines. And there's so many people that have come forward to immigrate from the Philippines in this category that it actually works backwards. And the way it works backwards is once, and we're talking about when a child's over 21, when the petitioner parent becomes a U.S. citizen, what happens is it moves to first preference automatically, and from that point, the number of years the beneficiary waits actually increases by years, does not decrease by years. Well, the Child Status Protection Act saw this happening and thought that that was quite unfair. So it made a specific provision, and it doesn't exactly mention the Philippines in this provision, but that's who it applies to. It says if the lawful permanent resident files the F2B petition initially and then naturalizes when the son or daughter is over 21, it does state that it knows that the petition automatically converts to a family-based one preference. However, under the CSPA, the son or daughter may elect to opt out of this automatic transfer by filing a request with the USCIS. And then what will happen is the F2B preference will retain the original priority date and will retain that preference as though the parent were not actually a U.S. citizen. And what will happen is it will allow that particular son or daughter to immigrate years earlier, again, as though the parent had never become a U.S. citizen. And again, while most of the world this doesn't apply to, it does apply to the Philippines, and it is applicable to help in this particular case. Okay, more in the coming videos.